Everyone who's managed to join us. Um, this is a topic that has taken the world by, has had a lot of interest around the world, with Dubai emerging as a major destination for financial and commercial dispute resolution. I can think of no other person who is more apt or apt to actually talk about this than Professor Jayant Krishnan. For a more detailed introduction of Professor Jayant, right? Raj, all yours.
Okay, great. Thank you so much, Arya. First of all, I would like to thank all of you who managed to be here for this wonderful and important book talk. The book itself was released just last week in Dubai, and Jay, as you know, is one of the world-renowned empirical scholars, and one of the things that doesn't happen much in India, and his really most authoritative work on Indian legal education, Indian legal profession, now on African legal education and legal profession, and then of course work related to now Dubai, shows that his extraordinary commitment towards transnational and global legal conversations surrounding many aspects of the profession. This, of course, is a very unique work, because one would think that on issues surrounding many aspects of, I would say, public law and human rights, the countries, particularly in the Middle East, but also in many other parts of the world, are much more resistant towards international presence of any kind. The idea of reluctance to accept an international adjudicatory mechanism is deeply embedded in jurisdictions and countries which are more wedded to stronger notions of sovereignty. But here we are, Dubai having an international financial court and accepting the possibility of an international jurisdictional framework in Dubai shows what is even possible in a context of this kind. So I'm very, very delighted that Jay has attempted to pursue research on this area. Of course, on a more personal note, this entire university and law schools, its early origins, and even before I knew the existence of Naveen Jindal and anybody, it was Jay. In fact, way back in 2006, when we had the first conference on 11th, 12th and 13th of August 2006, and even before, I had the privilege to begin the conversation surrounding the possibility of building a global law school at a global university in India. And so Jay has been a true friend of India, a true friend of the idea of this institution, and has tirelessly worked hard to build our substantive collaborations. I think he's also a beacon of inspiration for young scholars whose commitment to and dedication to research and knowledge creation and publications. I always feel when I hear our faculty members sometimes complain about teaching and research, I tell them about what Jay does in terms of teaching and research and administration and travel and family, kid, and all of that. It's just extraordinary. So I'm very, very grateful to Jay for his presence here. He's not a stranger to the university. He keeps coming here. People in the US think he lives in India. So that's the kind of, and his work is like that. Last couple of years ago, he made some 14 trips to India. He did this major project funded by the Ford Foundation on lower courts in India, which was published as a comprehensive 50-plus page article in the Harvard Human Rights Journal. I invite you to read that work. His substantive work on legal education was published in the American Journal of Legal History. So that's the kind of versatility and the intensively rigorous scholarship and engagement that Jay is known for, and this book is also a reflection of that. Lastly, I would say, from an institution building standpoint, he has mentored many of our young faculty members. Some of them are in this room now, but also many others. And also he is the champion of the dual degree program. As some of you know, the first ever LLB JD program. We started in Indiana University Bloomington, and then since then it has grown into Arizona and Cornell and other places. So what can I say? He's a soulmate in that sense, an institution builder par excellence, and we're very fortunate that he continues to come and inspire us. Thank you, Jay, for being here.
No, well, thank you. Thank you all of you for being here, and my friends and colleagues here at Jindal for hosting me. You know, I hope to get that type of introduction at my funeral. So that's if I can get something like that, I'll die a happy person. So I just want to say this is an amazing institution, and I'm honored beyond words to be able to be here with all of you today. So thank you. So let me begin by providing an overview of the book, which is here, and it's actually now on your online library system. So I want to make sure that it's available to all of you. What I'll do is let me just start by highlighting how there are really 5 chapters in the book, and I'm going to discuss the main points and arguments made within each of them, and I'll have just a few slides as well. And you know, feel free to ask questions throughout the talk too. I'll keep this relatively short, 20-25 minutes. And then we can have a bit of a discussion, maybe 30 minutes at most. So the introductory chapter begins by noting how 20 years ago, the government of Dubai made a decision that would forever alter its future. In 1998, the ruling family announced that it wanted to transform Dubai and Dubai's economy into one of the world's leading financial center. And in a sense, the plan was audacious. It's true that Dubai had resources and capital, and its leaders had the will to make this initiative a reality. If any place in the region could be the new global hub for trade, business, and economic development, surely Dubai stood at the top of the list. But at the same time, there were certain factors that couldn't be ignored, especially by foreign investors. For one thing, the local language was Arabic, which it was one that most investors from Europe, the United States, and Asia didn't speak. There was also the reality that these investors were unfamiliar with the local political and social culture and landscape of Dubai. And then there was another looming issue that worried foreign investors during this period in the late 1990s. Dubai's legal system, these investors feared, was not equipped to handle the complexities of cross-border international commercial transactions. But to the government's credit, between 1998 and 2003, it sought the counsel of 2 elite London-based law firms, Clifford Chance and Allen & Overy. And the purpose was to determine what the government needed to do in terms of legal infrastructure in order to make Dubai an attractive place for foreign investment. Ultimately, in 2004, the federal government of the United Arab Emirates authorized Dubai to pass what was called Law Number 9, as you see there, which created a global cosmopolitan business campus. The Dubai International Financial Center was established in order to attract foreign investment and to make the Emirate an international hub for commercial transactions. So the government basically stated its objective, to promote Dubai's geographic position in the Gulf as a significant strategic advantage for international investors. It was supposed to be a gateway, bridging those working in South and East Asia, the Middle East, Europe, Africa, and the Western Hemisphere. And the government also wanted to provide these investors with a familiar set of English common law courts that they could be comfortable with within the DIFC. And so beginning in 2005, the DIFC court served as the adjudicatory forum for all commercial disputes within the DIFC. In 2011, following the passage of, you see there, Law Number 16, the DIFC courts additionally were granted jurisdiction over any commercial matter, domestic or international, so long as all of the parties gave consent. And since that time, Dubai's government leaders have promoted the DIFC courts with great enthusiasm. Western common law and Western legal principles are used, as is English, in order to make the DIFC courts accessible to the global legal world. And you have to remember that we're talking about this occurring in Dubai, an Arabic-speaking Islamic monarchy. So furthermore, the judges of the DIFC courts have been internationally respected, with the goal being to ensure that the DIFC courts are seen as efficient, just, and legitimate. In fact, I'd say that this arrangement of DIFC courts within the UAE is just another example of how globalization is reconfiguring the relationship between legal institutions and political systems in the 21st century. So the focus of the book is on the DIFC courts and how they've operated since coming into existence. The book examines the reception the courts have received, both domestically and internationally, as well as how effective they've been at delivering adequate legal remedies. And the underlying question of this project is whether a Western-style common law judiciary can be exported to a country such as the UAE. And the answer, this book argues, is yes. Although, as I'll also talk about, constant vigilance is required in order to ensure that such courts remain independent. So that's what I would say are the big issues in the introductory chapter. The rest of the introduction then places the project within the larger scholarly literature that you see there. And here the underlying point of this discussion is that the emergence of the DIFC courts adds another layer to the broader scholarly discourse on how law and legal actors operate in this era of globalization. And I'm happy to talk about these different aspects of each of these works in the Q&A if you would like. But the bottom line here is the following. The study really builds on much of these previous works by showing how since 2005, Dubai has affirmatively and boldly introduced common law courts into its mainstream judiciary. And as the book tries to demonstrate, this experiment has been, I think, an overall success, mainly because of the cooperation of the Dubai government and the foreign actors involved. So in sum, drawing on extensive interviews over a 3-year period with key stakeholders involved in the process, along with all of the original documents used to establish the courts and all of the court's judgments, the purpose of the book is to provide a comprehensive and nuanced assessment of this institution, noting the accomplishments and challenges that it has faced. Okay, so from there, our story then moves to chapter 1, which focuses on the establishment and the development of the DIFC courts. Now, even though the idea for creating the DIFC complex emerged in the late 1990s, it wasn't until a few years later where plans for the courts began to gain steam. One of the key people in this process, maybe some of you know who he is, was the founding Chief Justice, a gentleman named Sir Anthony Evans. And he worked with another prominent local Emirati named Dr. Omar bin Suleiman, a well-known business executive who was recruited to the DIFC in 2004 with the expectation of transforming the center into a first-rate global financial complex. There were other key appointments made early on as well, from both abroad and domestically, and there were also close ties that were developed with the local Dubai courts, as well as Sheikh Mohammed's Ruler's Court and the Dubai government's important legal affairs department, all of which the DIFC team believed was crucial in order to develop domestic legitimacy. By 2005, the courts began to hear their first set of cases, with Sir Anthony and a Singaporean lawyer and judge, a gentleman by the name of Dr. Michael Wong, presiding. And they presided individually at the courts of first instance and then together at the DIFC Court of Appeal. And I would argue that having these two eminent jurists as the primary adjudicators in the early years was a clear indication of the government's desire to showcase to the world the independence and international bona fides of the DIFC courts. In 2008, when more cases started to enter the courts, we see 6 more judges added to the courts. Again, primarily foreign judges. I think that's important to keep in mind. And at the end of this chapter, of chapter 1, the book provides brief bios on them, as well as on all of the judges who have sat on the bench. But this period was also important because 2 prominent English barristers, Michael Black and Tom Montague Smith, had been brought in to finalize the rules of the DIFC courts. And this procedural framework was based on the rules of the UK's Commercial Court, which were held in very high regard by practitioners around the globe. And what these rules did was to provide a formality, or what we might think of as, quote, officialness to the institution, which, coupled with the technological sophistication that was adopted, made the DIFC courts a pretty remarkable experiment in a very new environment, again, that was not their own. The next part of Chapter 1 then focuses on the organization and the workload of the DIFC courts, and here you can see the structure of the courts. It's pretty basic. This part of this chapter discusses how there's a small claims tribunal, a court of first instance, and a court of appeal. But I do think that there are some interesting points here, data points, that deserve to be highlighted. So, for example, since 2015, the small claims tribunal has heard over 200 cases. In fact, I think it's safe to say that the proudest achievement of the Small Claims Tribunal has been that approximately 90% of all the cases brought to it settle within 4 weeks. In addition, the courts operate as smart courts, where the technology that they possess allow parties to access the proceedings remotely, which facilitates further dispute resolution. But this idea of settlement is something that I want to focus on because it's not just important at the small claims level, it's also important at the Court of First Instance and Court of Appeals levels. So consider this, consider some of this data here, which is that between 2005 and 2017, at the Court of First Instance, where the most complex of cases were heard, on average, 92% of the cases settled well before trial. And I think this prompts an interesting question, which is that the presence of the DIFC courts has not really been to promote litigiousness. It's been rather the opposite. And I think this is a finding that we see in the law and society literature as well. And that's namely that if a court is doing its job and its judgments are perceived as legitimate, efficient, final, and enforceable, then rational parties, many of whom will have contracted for the DIFC courts to be the forum to settle disputes, they won't need to be in court in the first place. In fact, the idea is that they opt to go to trial. Well, then the DIFC courts are there to serve them and to do so with efficiency and legitimacy. Okay, so that then takes us, I think, it's a good segue to Chapter 2. And Chapter 2 is the longest chapter in the book. And what this does is to examine the jurisprudence of the DIFC courts in the early years, and then to tackle a question that many people have discussed, and that is the extent to which these decisions are enforceable. Now, there's an important note to emphasize, which is that the discussion of the case law in this chapter, for the most part, stays clear of the DIFC court's decisions on arbitration awards. That material and a detailed analysis are saved for Chapter 3, which I'll get to in a few minutes. With that said, Chapter 2 starts by looking at what we might call the first era of judgments, from 2005 to 2011. Several of the cases that the courts heard initially dealt with questions relating to conflict of laws, jurisdiction, regulations, banking, employment law, and, as I say, enforcement of foreign judgments. In fact, in this first era of significant decisions, these issues often overlapped in the cases that came before the judges. So consider the 2009 well-known case of Rasmallah Investments. This matter centered on an employment dispute, with a group of claimants arguing that they had been unfairly dismissed by the Rasmallah company. The claimants sought compensation for this dismissal in the Small Claims Tribunal. And the tribunal applied UAE labor law to provide 3 months of compensation for the termination, even though there existed a DIFC employment law that governed but didn't provide this type of remedy. The case was then appealed to the Court of First Instance and was heard by Justice Tan Sri Yaakob, whom some of you might know, a Malaysian judge. She was actually the first female judge appointed in the UAE ever, of any court, and it was appointed to the DIFC courts. Pretty amazing, I think. Now, 2 years prior, the Court of First Instance, with then Deputy Chief Justice Michael Wong presiding, was asked by liquidators in a case known as Forsyth, which is cited there, to use either UAE law or English law to determine how best to prioritize outstanding debt claims. Justice Wong, at that time, refused, and he said, no, we have to apply the existing DIFC insolvency law, which did not provide for any type of prioritizing. And so what Justice Yaqub did was, basing her decision on Forsyth, she stated that the claimants here could not contract out of the DIFC law. She was unwilling to impute the UAE's non-DIFC labor law in this case, and so as a result, the lower court's decision was overturned. Other decisions during this first era highlight a loyalty by the DIFC courts towards DIFC law as well. There was a very famous case known as Injazat Technology versus the Denton Weil law firm that you see there, where Injazat brought a case to the DIFC courts, but the law firm made the argument that the contract between them mandated that any dispute between the parties be handled by arbitration in front of the LCIA in London. And so the law firm moved to dismiss the case. Justice Sir David Steele was presiding, and he declined the law firm's motion. Following the rationale of both Forsyth and Rasmallah, Justice Steele again strictly applied DIFC law, which he stated required that the case be able to proceed. But he was not happy about it. In fact, in his opinion, he says, quote, "I would have granted a stay if I had authority to do so." Now, what I'll say is that beginning in 2011 and really continuing through what we might call the second era of the court's judgments, we start to see a new set of norms emerging. Oh, I'm sorry. For example, you have the National Bonds Corporation versus Talim case, where we see the Court of Appeal holding that references in agreements to, quote, courts of Dubai necessarily had to include the DIFC courts. To hold otherwise, the DIFC court stated, would denigrate the status of the DIFC courts and go against the government's interests. So you see here a move to integrate the DIFC courts into the mainstream Dubai judiciary. The next year, in a major decision known as Corinth Pipeworks, we see now Chief Justice Wong writing for the Court of Appeal, holding that the DIFC courts can indeed have jurisdiction over a case even if there's only a slight tangential connection to the DIFC. And in my view, I would argue that Corinth set the stage for the DIFC courts to begin taking a much more expansive role. Concurrently, we also see during this period the passage of an important amendment, Dubai Law number 16 of 2011. Which enhanced the court's jurisdiction, thereby allowing parties anywhere in the world, as I said earlier, to opt in to the DIFC courts. And as a result, over the next few years, we see the caseload of the Court of First Instance and the Court of Appeal increase. And I think correlatively, given this increase in the caseload, we see some interesting developments occur. So for the first time, we see the DIFC courts agreeing to hear a case that involved Islamic banking practices, if you can believe it. We also see in other separate matters the DIFC courts refusing to cede jurisdiction to a court in the Emirate of Sharjah, and in another case to a court in Saudi Arabia. But the issue most salient during the second era of cases revolved around how foreign judgments would be treated. In fact, what's become to known as the pivotal DNB cases, the DNB case, the Court of Appeal was confronted with a straightforward question. To what extent would the DIFC courts recognize and thereafter seek to enforce a foreign judgment within the DIFC? DNB in this particular case had argued that an English court judgment that it received should be seen as legitimate and enforceable within the DIFC. And the Court of Appeal agreed with this position, as well as DNB's follow-up argument that the English ruling would no longer be a recognized foreign judgment, but would simply be a judgment within the meaning of Dubai's laws, and thus available for referral and enforcement by the domestic Dubai courts. This willingness to serve as what is called a conduit to the domestic bench marked, I think, a significant proclamation by the DIFC courts that it was taking its raison d'etre to heart, namely that the courts existed in order to promote and facilitate an international commercial activity within the emirate. And I would say that the DNB case made the court really feel empowered because of what had happened actually thousands of miles away in a courtroom in Australia. In 2014, the DIFC's Court of First Instance had ruled in favor of a claimant in a case known as Gricilia, and Gricilia is there. Here, the claimant had argued that the defendant had damaged the claimant's technological information system. But the defendant's assets were located in Australia. So what did the claimant do? Well, the claimant decided to approach the Australian court, using as its guidance a memorandum of understanding between the DIFC courts and the Australian judiciary. Now, sure, this memorandum of understanding was not binding, but it did set out clear procedures for recognition and enforcement of foreign judgments. And to the great delight of not just the claimant, but to all of those at the DIFC courts, the Australian court adhered to these principles and affirmed and enforced the DIFC court's ruling. And in my view, these developments really highlight what we might see as what I would call the two-way internationalization of the DIFC courts. On the one hand, I would argue the courts were keen to provide their counterparts abroad, as well as foreign lawyers and foreign parties, the assurance that Dubai and the DIFC courts were open, fair, transparent, and globally attuned. And at the same time, in order to have global legitimacy, it was vital that the court's rulings would be seen as valid abroad. And I think the events that occurred following the Gricilia case were a major step forward in this direction. Now, the doctrinal analysis of this second chapter ends by focusing on the major cases that came before the courts in the 2017 calendar. There were a series of contract-related cases where the Court of First Instance, in 3 separate matters, ruled against respective defendants who breached and failed to live up to their financial obligations. And perhaps not surprisingly, this issue of jurisdiction and enforcement emerged again in 2017, where the DIFC court simply reiterated that they could indeed enforce a foreign judgment within the emirate. And I just want us to think about that for a moment. We have a foreign court telling the domestic Dubai courts, you have to listen to us when you're enforcing a foreign judgment. Again, I think it's pretty remarkable. But I want to also say one other point, which is that during the 2017 calendar year, particularly at the Court of Appeal level, there was a slight twist to this narrative. The Court of Appeal's decisions in 2 key employment cases, respectively, showed a judiciary returning to more of its conservative pre-Corinth tendencies. And at the same time, there was this highly publicized case, maybe some of you know about this case, involving the English lawyer David Haig, who worked for a Dubai company and was criminally tried by the Dubai domestic courts for embezzlement. But he was also civilly sued in the DIFC courts for liability. So there were parallel proceedings, a criminal case and then the civil case in the DIFC courts. During the civil case, Haig was found to be in contempt by the DIFC courts, Court of First Instance. And the Court of First Instance was so angry, they issued a summary judgment in favor of the defendants, and they said that he had to pay. But at the Court of Appeal level, the DIFC courts remanded the case back to the Court of First Instance and allowed Haig to move ahead with his defenses in spite of what the court considered to be pretty outrageous behavior. And in my view, this decision showed a DIFC Court of Appeal that was tolerant and willing to permit a case to proceed in order to protect a defendant's rights, even though he was frankly being belligerent and being a jerk. And so they said, we'll allow this case to proceed. Ultimately, this past July on remand, the Court of First Instance found against Haig, who was ordered to pay damages in the amount of $6 million. But what all this says, and the book tries to argue this point here, is that the courts, as they evolved, wanted to carefully position themselves in a fashion so that there could be no question that they were first and foremost a neutral decision-making institution that had to faithfully follow the law, even if that meant rendering decisions that at times would seem to project the courts in a rather bold light, while in other situations issuing rulings that appeared, in fact, more restrained in nature. The remaining part of Chapter 2 then discusses whether these court rulings are being translated from judgments on paper into tangible relief for the winning side. And even though there was early skepticism, as time has showed, various court judgments from the DIFC have been recognized and enforced onshore in Dubai, within the UAE, around the region, and in different parts of the world. And I'm happy to talk about this during the discussion period. Chapter 3 then begins, this is the penultimate chapter, begins by noting how this year, 2018, marks a pretty momentous period in the court's history. It serves as the 10-year anniversary of the Chief Justice's tenure, but it also serves as the period when he's now retiring. And as I learned from him, as well as many others who I spent the last 3 years with, there have been some really interesting recent developments regarding the DIFC courts and the local Dubai judiciary, where the Dubai judiciary, the domestic Dubai courts, have started to push back. And let me explain what I mean here. Specifically, what we see is the passage by the Emirate of Dubai of a decree known as Decree 19, and the formation of a separate body known as the Judicial Tribunal. Now, it should be noted that Decree 19 was passed in the context of a DIFC judiciary that, again, had not shied away from being bold, from being pretty expansive. Given this, I think it's perhaps not surprising that there would be tensions between the domestic courts and the DIFC courts. And this was most accentuated when it came to the enforcement of arbitration awards. Now, we've talked about foreign judgments. This chapter focuses on arbitration awards. And now I should explain that under Dubai law, a party is permitted to enforce a foreign arbitration award in the DIFC courts and then seek execution in the domestic Dubai courts. And moreover, the local Dubai courts and the DIFC courts are to act reciprocally towards one another when it comes to recognizing and executing arbitration awards, including those that are foreign-based. So given this explicit language, and by the way, the UAE is a member, so those of you who know, is a member of the 1958 New York Convention. Okay, so given this explicit language that we see here, it shouldn't be surprising that the DIFC courts would seek to apply this to the cases that emerged. And we see this occurring in a case here known as Egan versus Ieva, as well as a Court of Appeal decision, a well-known case called Banyan Tree, where it was held that a foreign arbitration award was enforceable even when neither party was based in the DIFC and where the arbitration seat was outside of the DIFC. And the DIFC courts have now also been willing to stay a DIFC judicial matter when a foreign arbitration matter is pending. And I would say that these types of decisions highlight a DIFC judiciary that has seen itself to be a global international institution, which understands, respects, and enforces commercial law outcomes that occur outside of Dubai, within Dubai. And for a while, the local Dubai courts were okay with this. They didn't really push back. But then with the introduction here of Decree 19 and this joint tribunal, which, by the way, the joint tribunal was created and it has 7 members. And think about the makeup for a moment. 4 members are from the local Dubai courts, 3 are from the DIFC courts. So already you have a split in blocks, right? And in fact, in the first major ruling of the Judicial Tribunal, you have this case called Oger versus Daman, in which a split tribunal with the DIFC judges being in the dissent, in the minority, the majority ordered a stoppage of an arbitration enforcement proceeding that was occurring in the DIFC courts and said that the domestic Dubai courts had to give approval. As it turned out, ultimately, the Dubai courts ruled against the claimant who was seeking to enforce the arbitration award, and the case was dismissed. In the post-Oger era, the book talks about how there were other important cases during 2016 and 2017 where there were similarly split opinions from the tribunal, ordering the DIFC courts to stop their proceedings and to cede jurisdiction to the Dubai domestic courts. And you see this here. And of course, to many people, this type of move caused enormous anxiety about whether the DIFC court's time was coming to an end, whether their independence now had been totally curtailed. But I think what this chapter does is also to make an important observation, which is that the majority of cases, and I've listed these at the bottom here, the majority of cases that the tribunal has heard have actually, counterintuitively, believe it or not, have been unanimous. And here I would argue what this shows is that for the most part, even despite all of the hype, there haven't been major differences between the domestic judges and the DIFC court judges within the judicial tribunal. The fundamental approach as to how conflicts of jurisdiction are to be resolved have been unanimous. Still, I think it's important to note these developments of Decree 19 and what the judicial tribunal mean for the DIFC courts going forward. As this book went to print, I should just mention, the DIFC Court of First Instance just made issued a ruling that the legal commentator Gordon Black is described as providing, quote, encouraging sobriety and breathing life back into the DIFC courts. In addition, there's been a discussion, I've talked to Emirati lawyers who have said that there's no doubt that Decree 19 will be reformed as well. And then this leads to the concluding chapter that I'll just spend the last minute here talking about, which is what are the implications of the DIFC courts for other jurisdictions? Specifically, we see other global commercial courts emerging in places like Abu Dhabi, Singapore, Australia, Belgium, China, France, the Netherlands, Kazakhstan. With all of these developments, I think we need to ask ourselves what impact might there be on the longer standing commercial courts that have existed in places such as Delaware and New York, London, Hong Kong, and New South Wales. I mean, to me, it seems hard to imagine that given their reputation, these older, more respected courts would really see much adverse effect with the growth of these other newer courts. But can the same be said for the DIFC courts? What might this new competition mean for them? Then there's the question of how the courts will continue to be staffed in the future. As of this November, as I said at the beginning, we have a new Chief Justice, who is actually the former Chief Justice of Malaysia. And we have a new Deputy Chief Justice. And here, it's very interesting. For the first time, this Deputy Chief Justice is an Emirati, all right? A local Emirati. And this has begun to spark a quiet debate among various constituencies as to whether the Dubai government has plans to nationalize the DIFC courts and eventually replace all of the foreign judges with domestic ones, and how the international investor community might react to this development if it were to occur. To be sure, jurisdictions contemplating establishing their own commercial courts, I think, are astutely watching the events in Dubai to see how all of this will play out. And they're also looking for lessons that they can apply to their own respective contexts. And from my perspective, I really believe that the framers who boldly established the DIFC courts, I think they clearly deserve heaps of praise, as you can tell from my argument. And I'm hopeful and confident that all of the good work that's been done to date will continue into the future. But as we've seen, there have been various challenges that have emerged over the years, and new ones are certainly to follow. And the way that the courts, the DIFC courts, and other important stakeholders respond to existing and future hurdles, I think will likely determine what becomes of this institution. So for now, we'll just have to wait and see. And we'll have to think good thoughts that what will transpire over the next few years regarding the DIFC courts will be beneficial to the Emirate, to the UAE, the region, and to the global commercial community. Thank you.